Charter as the common law. Well, the Great Charter is Magna Carta. Okay? And the king has said, look, you guys, he's talking to his own staff. He's saying, the Magna Carta is the common law if the defendant demands it. Okay? So you want it in print, go to the Magna Carta. And the Confirmatio Cartarum makes the link between the United States constitutional recognition of common law and the Magna Carta. So Magna Carta is still good law today. Does that answer your question? Yeah. Okay. Back to procedure here. Elements of a common law action. Basically, it starts with the declaration. When you make your declaration, that's your accusation. There are several kinds of actions in common law. And here they are. Basically, in common law, there are 11 common law actions. Now, when you put together your lawsuit, there are certain elements that go on the paper. You got to have the title of the court, the name of the court, like, for instance, the Superior Court of the State of California in and for the County of Orange. Okay, that would be an example. The venue, that would be in the County of Orange. Okay? And then you select the forum. So, at the commencement of your lawsuit, in other words, the first paragraph, you say who the defendants are and what the forum is. And the forum in this case would be a court of record, as opposed to, let's say, an equity court. Okay? So, once you've identified the forum and the parties, you decree what the law of the case is, because you may recall from prior discussions about sovereignty that the sovereign decrees the law. There is no law until some sovereign decrees it. So when you bring your case in, what's the law? Well, you're the sovereign, so you say what the law is. Remember, it's the job of the jury to judge the validity of your law. So I've had trouble enforcing the pink shoe law. But you decree what the law is. And then after you've done all that, now you get into the actual case. So you have 6 different kinds of torts, and you have 5 different kinds of contract issues. Okay? So in your case, in all likelihood, it's either going to be trespass on the case, or maybe I'd say special assumption, probably. Those are the most likely ones that I see that you would run into. So, what is trespass? Well, trespass means that you were injured and there was some sort of violence involved. Now, the violence can be implied or it could be actual. Either way. A good example of violence is, what if you're arrested? See, that required a violent act. That required physicality. Okay? That would be trespass. Now, don't die on us. We need you. So, there's trespass on the case. Now, trespass involves injury, but no violence. Okay? For example, let's say somebody conned you out of some money. That would be trespass on the case. Somebody set you up on something. It's all fooled you somehow, or violated your rights, but without actually getting physical. The special assumption, that's breach of a simple, unsealed contract. There's also covenant, but covenant covers a breach of promise under seal. In other words, you have a contract, and you sign the contract, and then you seal it with a seal where you actually crimp the paper. Okay? When you have a contract under seal, or if you put wax on it and then you stamp it the old-fashioned way with a little thing to put your symbol on it, actual seal. When you have a contract like that, that's called a covenant. And but if you don't have the seal, then it's called a simple contract. And yes.
What about trespass on the land?
That's the same thing as trespass. That's under the that is trespass, not trespass on the case.
Is the sign stronger when you have a sign not to trespass? Does that give you more strength, or?
Well, yeah, it should, because a person could be walking along. He doesn't know where the border of your property is. If you just have open land, if there's some clear indication, if you have a sidewalk leading to your door, a person walks up there, that isn't necessarily trespass. But if you have a gate up and it's locked and somebody jumps over, that may be trespass. Yes.
Is assault a cause for tort?
Yeah, assault is a tort, and it's trespass because it's violence. It involves physicalness. Okay. So it's not paper. If I manage
verbal assault.
Well, that's a gray area, I guess, verbal assault, but I suspect that's trespass on the case because there's no actual physical action, just talk. Just talk. Yes.
I just have a question on the contract with debt. Does the debt have any kind of promissory note or any kind of agreement?
Yeah, debt just means somebody owes you money. The question as to why they owe you money is not part of the picture.
So we don't have to have any kind of proof of the debt?
Well, you sue for debt because the person owes you money. That's it. That's the issue right there. There's no question he owes you the money. The question is enforcement. So you go to the court and you say, hey, I need help in collecting this debt. So the debt's not in question. Of course, the person could answer and say, I never owed you, in which case that changes the character of things. But nevertheless, if it's just a pure debt, you just go to the court and you ask for a court order. And you sue them. Sue for debt. On the other hand, if there is a question, then you might sue for a special assumpsit breach of the contract. You're saying, hey, you promise in your contract it says that if you fail to perform, you will pay me so much per day.
But would it apply for verbal contract?
Sure.
Verbal agreement?
Sure. Yeah. The general assumpsit applies to breach of implied contract, which is what your verbal contract would be.
Counterclaim?
Counterclaim?
Yeah, if you were...
Well, counterclaim falls in the same set of categories. It's if you're doing common law, you're going to follow one of these 11
Correct.
items. Okay. Now, then you have to specify what your rights are. Okay, you have a right to not be disturbed, or you have a right to be paid, whatever it is that you're entitled to. This is your entitlement, and that this person is wrongful in what he's doing. Okay, he is either doing something or he's not doing something he should be doing. Okay, so either way, it's a wrongful act. And then you have the injury that you suffered, and then the conclusion, the prayer. In other words, you're asking the court to award, and you sign off on it. Yes.
The question I think she's leading to is that there was a person who borrowed and failed to pay, filed in the bankruptcy court, and misfiled the numbers. Instead of the larger number, filed a small number. Can she then cause that person in the bankruptcy to default on her number that's correct?
Well, you sue her. You sue him.
Can't you do it through a default just by letter, and then she defaults in 72 hours under the...
Well, if you're talking about a notice and demand, and you're getting into the UCC, which I claim no knowledge of.
Well, you do cover it in your website. You do pretty good with it.
Yeah, but I don't claim to have solid knowledge in that area. Okay. The minute you say UCC, I go dumb.
I didn't say UCC. I just said default.
Sure sounded like it.
I said the word default.
Well, default in the UCC, right?
So if someone doesn't respond to your demand, then that...
Well, in theory you could do that, but remember, you don't have the power. Okay, so I you don't have the physical power to enforce your default.
Well, you take a notary, then you take your notary and she creates the default.
Well, if you have that, and that's another system I haven't looked into, which is really a subset of the UCC business. Those are areas that I have yet to study. What I know is court procedure.
Correct.
Okay? how to operate a common law suit in court. This is what I know. Yes?
But if your name is already filed on the bankruptcy court, so can you still do a notice of demand?
Absolutely. You sue them. I wouldn't spend too much time on the notice of demand because you've already been named as a defendant.
So you sue in the bankruptcy court or outside?
No, what you do is you would, I think, you would sue wherever you're going to sue. But the bankruptcy court has to be notified that the suit is going on because that is an adversarial action. And the purpose of bankruptcy is not to settle those lawsuits. The purpose of the bankruptcy is to distribute the assets among all the creditors. They don't get involved in disputes. And they cannot settle the accounts until all the accounts are settled. Okay, you got to get rid of these disputes. So you sue and you notify, but there's a procedure to follow. Okay, so you need to look at the bankruptcy rules and find out exactly what the method is for letting them know that you have an action going. And maybe the answer is to actually sue in the federal court and then have it removed to the state court. It might be a roundabout way, but whatever it is, the one thing I do know about bankruptcy court is that their purpose is not to settle disputes. And they cannot move forward until all disputes are settled. We did an interesting thing in bankruptcy court one time. There was a person that was declaring bankruptcy. And the first thing that happens when you do a bankruptcy, now again, I don't know much about bankruptcy, but I do know some general principles. And so she did a bankruptcy in a court of record. In the bankruptcy, the very first thing the court does when you file bankruptcy is they appoint a temporary trustee. Now it's her court appointing the trustee. Then all the creditors are notified. All the creditors have a meeting at some point, like 3 months down the road, something like that, whenever it is. And they elect from their own a trustee to represent them. Because the trustee, even though your court appointed him, the trustee works for the other side. And so, but your court has been set up. The truth is that you are the defendant, they are the plaintiff, but you started the process. But they don't know they're the plaintiff yet. And so a trustee is set up to represent them and to handle their affairs, and they dictate to the trustee what it is they want. And the amount of voting power that each creditor has is related to how big the debt is. So the biggest creditors have the most say. Okay? And so, but there's this point where you have this temporary trustee, and then you have the permanent trustee elected by the creditors, and then you get into a more normal court scenario. Okay, where the trustees representing these creditors, and actually the trustees has a little more responsibility than that. He's supposed to also be fair. Okay, also fair to the defendant as well. So it's not an adversarial action in the strictest sense. Anyway, the way bankruptcies are usually conducted, the creditors never show up. They see who the trustee is, and if they fail to show up and vote, then the new trustee is the same as the old trustee, and he now becomes a permanent trustee. Okay? So what we did on the day of the election, before the meeting, we went to the court and we filed a court order from the owner of the court, right? The person who filed bankruptcy, discharging the present trustee and appointing a new temporary trustee, one that we liked. Then we showed up at the meeting. The trustee stood up, the old trustee stood up, and we served her with these papers. saying, you're no